Oh, I wasn't up there yet. Can you hear me now? So listen. So, and I dropped the link. You hear me, Warrior? Hopefully I won't be long, but I need to have a common sense conversation, right? And again, all right, my whole purpose, as always, is to be factual and not full of shit. Okay, this is the R. Kelly sector, so we report on what R. Kelly shit. This is not the beef and bullshit sector, right? So I got a few minutes, and I want to have a conversation, right? Common sense conversation. And depending on how this time runs, I may read certain sections of the Illinois sentencing because I wanted to make some sense of. Let me write this down real quick. I need to make some sense of that money appropriations for the accusers, and so I may read those parts, right? So, but listen to this. Listen to this, okay? Because we're not need to have a conversation. Hopefully, Levi, somebody's around that can hit the link, or anybody that can have a conversation with me, because I woke up and I just been seeing this whole movement with the BOP shit or whatever. And I get it, right? You got a lot of people, you know, writing letters and reading emails and and the light skinned man Dre call and all this type of shit, whatever. And spin fight, get a call, whatever, and that's fine. I got to go back and listen to it completely. And shout out to all those people that's getting those calls and those emails and shit. It seems like R. Kelly is taking his movement in a different direction. Seems like he's leaving the ghetto in the streets. And once again, we get it right over here. I said a long time ago, he should have been listening to people like Levi and Sharon or whatever to kind of structure his movement. You know what I'm saying? And that ghetto thing, that ghetto thing is good for just what it's good for. Okay. But even when people organize the shit right, the ghetto people is usually led by non-ghetto people, even in the streets. I mean, shout out to everybody, put in the effort. That's not what I'm saying. You know what I'm saying? But it has to be when you're talking about getting up there where this case needs to be reviewed at that level, the ghetto, it ain't gonna work out. They're not gonna listen to that. Okay? They're gonna shut that down quick. First of all, you got a case where it's a lot went on. You understand what I'm saying? It's a lot went on. And you want them to review something based on the Constitution, right? The constitutionality of the whole, the whole situation. So you need to look at that, right? And hey, we did, R. Kelly said, we said they, I said, what we used to say over here, I said, you can't break the law to enforce the law. Remember, I used to say that a long time ago, and I said a couple times recently, but you can't break the law to enforce the law, right? And justice is for both sides. But with this whole BOP thing, so here is a whole bunch of technical difficulties with this whole movement, right? And this is what I am hoping that the aim is to at least, I guess they're trying to get this thing in front of as many eyes as possible. Of course, they can use the BOP thing as a springboard to talk about the inconsistencies and the just the whatever's going on with regards to the judicial system as it affected him, right? Hey, Stephanie, but we need to, I don't deal with a whole bunch of. I always have faith, right? Because you can't that's like without faith in anything that you do. You understand what I'm saying? It kind of you know seals your faith a little bit, right? It takes you nowhere. Without faith, you don't even try. So in some cases you be like, man, it ain't gonna work or whatever. So, but what I'm trying to say is I don't deal with a lot of do a lot of shit that I know it's not going to work. Like I always say, I don't get into a game if I don't have at least 51% chance of winning. Okay, I don't do nothing at least if I don't have at least a 51% chance of winning. Okay, I'm not gonna go out there and challenge Serena Williams in a game of tennis. I'm not gonna do that because I'm not gonna win. I'm not gonna even score a point. I'm not gonna do that. That's stupid. You know what I'm saying? So I don't like to waste a lot of valuable time on things that is just I don't think it's going to net anything. And now I'm going to tell you the the legal reasons, right? So, but first question I have is, do you, as far as Illinois, do y'all think that the prosecutors will appeal his sentence, right? I would surmise that they didn't like this sentence. You know, I don't think they will, but it's not like they can't. They can appeal his sentence, right? So I don't know if I doubt they will, okay, because they'll just look like they're just like an asshole, but you know, um, they can, right? And about this, so let me tell you this. Let me tell you these stages, right? Because I like to take y'all in the stages. But I got to go back a little bit, all right? So understand now, after his convictions, the burden of proof is on him, okay? So that means when it came to when it comes to this appeals process and going forward, the burden of proof is on him. Anything after he's been sentenced, the burden of proof is on him. If he wants to raise those objections to whatever, right? So that means that you can't simply just make a bunch of allegations, right? Like you can't simply say, oh, the girl read the emails and that's what made her flip and blah blah squaze is the thing. You got to have some type of, some circumstantial evidence. And again, the burden of proof is now on him. It's not on the prosecutor anymore. Whoever brings the action, that is the person who carries the burden of proof. So so they have to prove all of this. It's not enough to just to say it and think that it happened. You got to prove it now. Now, how you gonna prove it? And let's assume that someone at the higher level entertained this. Well, how you gonna prove it? Right, Stephanie, it would. They yeah, so how would they prove these allegations, right? You have nothing to substantiate what you're saying. You just feel like it happened, that you think the timing, so on and so forth, whatever, but you have to also think about this. Normally when it comes to the defendant and there's a suspicion that someone tampered with the witness, that's what it's called, right? That's the 18, what 18, 15, 12, right? But when it's done on the prosecution end, and that can be through the course of the legal system, it can start at, investigation or whatever, then that is considered prosecutorial misconduct. All right. And you got to prove that. It will, they'll say, in the case she lays out, be like, yeah, they tampered with the witness by doing blase squaze, this and that and the third, but it will still fall upon the prosecutorial misconduct. Again, you got to prove all of that. And here's the thing, right? When I hear him and then I see all these emails, I'm like, oh God. I kind of, feel sorry for him because it seems like he is like dependent on this. Like this is the golden egg or something. This is the key that's gonna, to turn the thing, the lock, and let him out. And I'm like, I'm wondering, are they telling him like, okay, we can try this. Let's try this. But then I saw email say, oh, he just focused solely on this. No. Cause see, I'm gonna tell you, I'm gonna give you some facts to why only I'm just giving hypothetical, right? Right now, hypothetical. If they decide to hear this, whatever, right? Then it still got to put through the test. And the bottom line is, would it have, if known or whatever, if this didn't happen or there's no remedy or whatever, barring all of that, right? They're going to still ask the question, would it have resulted in a different outcome in the case? They're going to ask that. And you could say if she wasn't there or she would have, that's some street ghetto shit. Don't work like that. Whether she was there or not. I mean, if she was, somebody would have subpoenaed her ass, okay, and made her be there. She could have gotten on the stand and said, I plead the fifth or whatever, right? Or she could have gotten on the stand and totally, you know, um, sided with the defense. At that point in time, it would have been just between each side to make her testimony out of credible or not credible, right? It's not no if she wasn't there or if she whatever. That's not that doesn't even factor in. They're not gonna even entertain no shit like that. Somebody was just simply subpoenaed her ass. Or even if she wasn't there, she was already in the paperwork anyway. So that's null and void argument. So scratch that off the list. I like to get to it. What's up, James Harris? I like to get down to the nitty gritty. All right. So keep in mind, it's on the burden is on the defense. Because if they bring the action, that's their burden now. So how they gonna prove all these allegations? Who knows? Okay. But let's talk about the technical reasons why this won't even be heard as a BOP email situation for New York. And it won't even make sense in Illinois. So let me tell you why. Y'all ain't gonna like this. One, the main reason, if anybody know where I'm going with this, you will know. This was not raised in the process in New York. It wasn't addressed during trial. It wasn't addressed during the post-conviction phase of it, the motions I'm talking about, right? So therefore, it's not on the record. So it's not going to even be a factor on the appeal. And I went and checked the dates. They had an article out about the BOP shit on September the 7th, 2021. His trial was going on from 8/18/2021 to 9/27/2021, right? So it was discoverable, meaning it could have been part of the discovery, which turns into evidence, right? None of that happened. And you can't put something and bring something on upon appeal if it was discoverable, right? Illinois is sort of addressed that. So that's why they said it wasn't a Brady violation, and they was really, I mean, they really didn't really have any part in it, but they had to address it because the motion was filed there. But they kind of addressed it for New York. So it can't be a very Brady violation if it was already known. So now it can't even be heard. Now, maybe when they do a 2255, right, a writ of habeas corpus, they can bring these type of things up. But once again, you still have to what? Prove it. Two, they don't have to ask that question. Well, you don't really have to prove it. I take that back. Because it's a loose operation with the habeas corpus. You know, damn near anything goes. You know what I'm saying? So, but you know, the whoever is making the decision is going to ask those questions, right? Would it have made a difference? And they're going to, even though I mean, it's, if I were you, I would try to prove what I'm saying to sway the trial fact, but which is the judge. But if you don't, you just risk having some shit out there just for the sake of having, something to say. So will this so most likely, if she uses this, it's going to be in the sense of talking about his violation of his constitutional rights. But keep in mind, that's a lot different than the violation of procedure at the BOP. That's a totally different argument. But prisoners do enjoy certain rights while at the BOP. But as we see, those rights do come with disclaimers, but there was some negligence and some liability within that disclaimer. So that kind of voids that disclaimer, which probably creates a civil lawsuit. Now, if he's demanding an investigation, fine, right? I believe that in answering her motion to compel in Illinois, they kind of addressed the investigation as to what happened, right? Because they, talked about the email that was sent to Angel Kroon by Larry and this, that, and the third, right? They kind of broke it down. So, you're so crazy. So, I don't know. And I'm just the type of person, I just don't like nobody to get their hopes up high, like, oh, this is the thing that's gonna free me. And I'm like, how you gonna get it to work, Sway? And I looked in some of Jabo's final filings, right? She didn't say nothing. She didn't make this BOP situation a big deal too much after she addressed it on that motion to compel and the prosecutors responded, right? So you can't use it in Illinois because it don't even fit. Because you're talking about it flipped Jane Doe number 5 from New York. So you can't use that in the Illinois appeal. So I'm trying to figure out where we going. Because all I see is a whole bunch of writing and a whole bunch of this and that. I'm trying to figure out where we going. You got to make the burden is on him. It's on him. This is what he's bringing. It's different now. Prosecutors done their job. You got to prove these allegations. Now it sounds good. And the man, Mr. Dre, he over there hollering. But if it ain't on the record, I don't know what to tell you. Hey, Lady Tech, if it ain't on the record, I don't know what to tell you. I don't even know how you get it in front of an appellate court. Just say you arguing, right? Okay, you arguing issues with regards to the law, right? That's if that means it was the law applied correctly. Was it understood? This, that, and the third, right? Well, the BOP emails didn't even come up. So there wasn't a ruling on it. There wasn't an objection to it. There wasn't nothing. It's not on the record. I just, no. Anybody can tell me, let me know. Because his trial, if I'm not mistaken, it started on August 18, 2021. And the verdict was in on 9/27/2021. That BOP thing was on the air. I found an article on 9/7/2021. I mean, it was already there. Now, could she say, all right, ineffective assistance of counsel, right? Because they did not, quite inquire about that. They did not bring that up. Fine. Ineffective assistance of counsel. But it's still going to answer the same question. Had it been known, had they would have been effective, whatever, did it prejudice the client, right? Would the outcome be different? You still got to put it through that test. I don't know how they make. I don't know, y'all. I don't know how this is going to work. But it's a lot. I don't know. He sounds so. Oh boy. Mm. Mm-hmm. I mean, maybe there's a different. No. And then like I said, I looked to see. I said, well, did she even mention that? That shit just scared me as hell. did she even mention it or anything like that? And no. Mm-hmm. Wait a minute, y'all. Just 1 minute. All right, sorry about that. So I don't know, y'all. I want to pull up some of that to see what the judge said about that money because I was trying to kind of confused as to why they didn't award. Let me say it like this: why he awarded like he did. So let me get to that. But yeah, like what y'all think about the R. Kelly calling and stuff? Hold on. My girlfriend said everything you have been saying is true. Oh wow. However, she said nothing supersedes his constitutional right. Right, you're right. Nothing supersedes his constitutional right. But here's the thing, right? And that is absolutely true. Because that's mandatory. You must follow that, right? But within the Constitution, that is subject to interpretation. And you got to prove how his constitutional rights were violated. And then will it make a difference? Would it have made a difference? You understand what I'm saying? Because Jada number 5 was already in the case. So whatever evidence they were going to use, absent her testimony, they were going to use it. She wasn't, an act. She was an act. So, but let me just one moment. Let me pull up. Let me pull up something. Let me pull up something, Lord. Let me pull up the sentencing. Hold on for a minute. This damn thing be about to shut my damn computer down. Pulling up this stuff. Hold on. Okay. So we are looking at. Okay, what page is that? All right. Let's see what he said about restitution. Okay. All right. So let's see what he says about the restitution. Okay, it says, now we proceed to the issue of restitution. I have a few questions that I want to raise on the issue of restitution. What did Judge Donnelly provide for restitution? Did she issue an order for restitution? Bonding, yes, Your Honor, she did. And we did have a restitution hearing. Her restitution order was approximately $370,000 roughly. I'm going to get the exact amount for if you give me a second. And there, of course, $379,649.90. What's up, Key? What's up, Cookie? What motion back in 2021? What motion are you talking about? Are you talking about the one that had Larry's name in it, or what is there another one? Let me know why I have this stuff up. It says, Your Honor, the restitution that was awarded there, I will point out, was based on actual data evidence of what it would cost to treat one of the victims, actually two of the victims, sexually transmitted disease that they claim that they received or got from Mr. Kelly, and for a lifetime supply of the drug that treats that. That is a hotly contested issue, and it will be raised on appeal in the Second Circuit. See, we getting some information here. Thank you, Keith. But I want to make clear that the number comes from an actual number for medication, one medication for the rest of their lives. It wasn't expert reports or any of the type of evidence that the government is trying to use here. In fact, I've never even seen anything of that type of evidence to be used in restitution. So that number was a number that was specifically connected to what the cost of a particular drug would be until the lifetime expectancy of two of the victims or three of the victims as I sit here today. And that's where the number largely come from, $379,000 and change. The judge says one of the questions I have, I guess, to the government is, and I appreciate the fact that the law provides that the ability to pay any restitution is not relevant or is not a defense to restitution. But does the government have any notions that there is something available somewhere? The prosecution said, Your Honor, we have the same information that you do as far as what's been, represented. And the judge says the government is his biggest creditor at this time, the IRS. Ooh. Would there be any basis that the IRS would yield to the defendant here, or will they insist on their rights as a lien holder? Meaning, will the IRS say, okay, never mind, the restitution or whatever they want to award be paid into first, and the IRS either go, get paid last or zero out their balance, right? That's what I mean. It says, and the prosecutor says, Your Honor, I think that's precisely why the statute says that these things should not be considered because it's looking into a lot of different factors. We don't know what's going to happen necessarily in the future. We don't, the courts have said that a defendant could win the lottery. That's the example the Seventh Circuit has used. So there's things that could happen in the future where he could, even if he has, a number of liens right now, that could change. Judge says, has the government done any research, or are you aware of any research by the IRS or by any of the judgment creditors that they found out whatever happened to his rights to royalties? But he is getting all into the money. Boy, this judge here knows his hell. No, he's just trying to make a fair assessment and an analysis and trying to make a reasonable judgment, what I'm saying, with regards to this money. So the prosecution says, no, Your Honor, we don't have that information. Let me see. Okay, okay, it's Ms. Bonjean says, Judge, I just want to point out I actually represent Mr. Kelly on a number of these civil matters. And what I can represent to the court is that it is entirely unclear. He does not know what percentage of royalty rights he even owns, frankly. That's one problem. Those royalty rights have been sold off over 3 years. It's not even clear what he owns. Second of all, the royalties that he has received previous to his Eastern District of New York case have now multiple liens on them. What was held by Sony is spoken for 2 or 3 or 4 or 5 or 6 times at this point, if you take into account the default judgments, which now with interest are close to $10 million. God damn, $10 million. Oh, that's why, honey, you got to read these goddamn transcripts. Them people in me ain't said nothing about this. In addition to the liens by the United States federal government, that is a part. Damn. So this idea that there is money out there and the government has restrained everything. So they know what's there. They know that there is nothing there because they've not been able to get it. So all I can say is, yeah, I suppose you could win the lottery, but the reality is he's going to prison. He does not make music anymore. He cannot make music anymore. Whoever leaking his music are the people making money, but he's certainly not getting any proceeds from any money. And whatever he has is spoken for. And we all know that his music isn't played because of the cancel culture and all that. And that's fine, but he's not earning income. And there will be no money unless something dramatically happens. Changes, I'm sorry. The judge says there was something on the internet. It says new R. Kelly album, I admit, is a bootleg, not an official release according to Sony. I mean, the judge Googling. Hell no. They know. Lord, y'all. We got to shut this shit down. I'm glad James Harris is here. Karen, where is the new board that we could put up? It's Our Channel by James Harris. Hell to the no. We are down here operating in a chop shop, y'all, in the boiler room. The fuck? He on the internet, his old ass, when he should be asleep. I'm putting the paperwork in on time. Okay. And I believe they quoted you saying that you knew nothing about it either. Jabo says, that's right, Your Honor. I don't think Mr. Kelly would have preferred that title if he was going to be releasing music, but that was not released in any official way. Unfortunately, as I mentioned, there's been a lot of financial exploitation of Mr. Kelly over the years, and a lot of his music has been stolen. Judge says, well, does anybody know who was responsible for that? Were there many sales, or, he all in the damn Kool-Aid, child. He want to hear "I Believe I Can Fly" with his old ass. He want to swing, and don't they swing in Chicago? Stepped in the name of love. His old ass. J-Bo says no, because as soon within like 24 hours, as soon as Sony said it was a bootleg, it was taken off the internet. So I don't know who released it. We did try to investigate it, but we just don't know who released it, who had it. And he certainly made no proceeds from that. And I'm not sure anybody did, because it was removed very quickly. Judge says, okay. Well, I have reviewed your both sides multiple submissions on the issue of restitution. And it seems that while the law does provide for restitution to the victims in this particular case, Jane, Pauline, and Nia, the government submission seems to follow the line similar to a tort case, a civil tort case, as far as seeking damages are concerned, although they phrase it in a particularly different way, right? So he is accepting J-Bo's argument that this should be a civil case. So apparently the damages raised in there are ones that are generally raised on civil cases, right? Okay, restitution covers other things. Apparently, whatever they raised injury and things of that nature that will fall under civil. Okay, it says, but the difference, it seems to me, that the restitution is meant to be a simple or relatively simple procedure whereby the victim get together their actual expenses, the proven expenses, and bring them into the court or to the probation office or whomever. And then look, he don't even know. He don't know where the shit go at. Okay? So that blows the motherfucking concept that attorney's supposed to know everything goddamn thing. Shit, he the judge, he don't goddamn know. And then I get a report, and then the court would then issue a restitution order that the defendant pay these bills. And I've gone through pretty carefully the submissions. The only really close to an actual item of actual expenditure is alleged by Pauline, who spent $42,000 for therapy services, most of which apparently were not covered by insurance. Wow. So I'm kind of the rest. I mean, they say that basically what they're saying is that they should have received all this medical care. They should have received all this therapy, all three of them, over the years, and therefore Kelly is responsible for what they should have had to spend, what they didn't. So it seems to me that what you're really talking about is a claim for tort damages, which, of course, if there it was a lawsuit and there was a multitude of lawsuits against him, which, of course, then you would have the concept of discovery and dispositions. So you can actually determine, cross examine the experts who claim that this particular condition or that condition is causally related to the actual misconduct of Mr. Kelly. Wow. That's not the purpose, as I understand it, of restitution. The purpose of restitution is to reimburse for the expenses that they were caused to incur, and also cause that for some future. But it seems to me there's been no evidence other than Pauline, I believe it was. One of them testified to $42,000 in. That was Pauline who actually, and that would be, if she did, then that would be the subject to restitution. Obviously, future matters which haven't occurred yet could be if they're actually, if they're casually related. But I'm just having a difficult time getting through how to handle this restitution. So maybe I should turn it over to the government and ask you if you want to comment on my comments. What kind of fucking shit is this? Is this a joke? It was a motion compelled. Oh, okay, yeah, that's the one I was talking about. Okay, that's the one I was talking about that we went over. So the judge says, yes, Judge, Your Honor, absolutely right. The restitution statute provides that the victims should be reimbursed for their losses reasonably projected to be incurred in the future. And that's in section 2259 that deals with the sexual exploitation offenses before the court. And that statute, Congress, and the case law that discusses it specifically points out is because the damage that is done based on those types of crimes is lifelong. And so people that have gone through that, and you've heard it from the victims themselves today, they're still struggling. They still need help. And so what we've tried to do is to put together information and assessments showing that there is still, one of many needs they have. But mental health care, you heard from the victims today, that is a top priority. It's expensive, and the defendant should have to pay for that, given that he caused this trauma by abusing them. And so, we put forth the case law in our memo here. It's not an exact science. We can't predict with certainty, the years of therapy that will be needed. But in many cases, Judge Kendall Whitley's decision, being one in particular, cited studies that show that it's a lifelong process. And so that's what we've come up with in terms of being able to estimate. And Your Honor can do that. You can estimate what will be needed based on the literature before you, based on Dr. Cooper's assessment that we put before Your Honor. So that is one of the main asks of the government that you impose. It's mandatory. Okay, so remember, I be teaching y'all. I'm not teaching y'all, Lord. I don't want to say that. I'm not teaching y'all. I be telling y'all. Lord have mercy. Remember, I be telling y'all mandatory, primary, secondary, right? So when you start hollering out mandatory, she's simply saying something that must be followed, okay? A law that must be followed. But then you hear them holler out mandatory. So when you see that in print or you see them holler that out, that means they're trying to say it must be followed. That's the legalese way of saying that, okay? It says each of these victims must receive restitution. And so the issue becomes the amount, all right? So that just substantiated what I said. She said each of these victims must receive restitution. So by him denying this, I don't know if the government is going to fight this even further, because they're saying that the restitution is supported under section 2259, right, in the law. So I'm not sure if the issue, falls dead here. It says, and so the issue becomes the amount. And so there's a lot of different ways you can calculate the amount. Sometimes you do have to kind of instruct the judge and try kind of make him refer to the law, because this is what happens, right? Of course, the prosecution knows all the laws and the statutes, whatever, that they're using to support their cause of action for this particular case, right? I'm not saying they know them all. They know it for this particular case. The judge is probably not going to know it right offhand, right? So sometimes you have to direct them as to what they can and cannot do, how it has been interpreted in other cases and things of that nature. So if it sometimes seems like the prosecution or the defense is telling the judge what to do, they kind of are, okay? They kind of, reminding him of what he or she can do, all right, based on the law. He might not have it, who knows when the last time he handled somebody being charged with 2259, right? So therefore he's not going to probably be familiar with everything about sexual exploitation of a minor, whatever that particular law is, right? So, and then what it all entails, okay, especially for its financially. So sometimes you have to tell them. So there's one of the reasons why the government had, asked for additional time for Your Honor to take these issues under advisement. they are somewhat complicated in terms of assessing all the information. So we wanted to make sure we had enough time to address those, allow defense counsel to weigh in on her arguments. And that's where the government's position is on this issue. The judge said, Ms. Bonjean, and Jabo says, yes, Your Honor. The government continues to say that restitution is mandatory. And that is true if they meet their burden. Ooh. Okay, all right, Jabo, swing with it, baby. It's not just you must give them a number. That is not the statute. They still bear the burden of demonstrating what the appropriate restitution number is. So remember, I just told y'all about the statute, right? How you can guide your judge through the statute, okay? All right. So it says the government suggests that you can just pull a number out of thin air based on some scholarly article somewhere. So in law school, and in law school, you would deal with a whole bunch of scholarly articles, all kind of reviews. And the article that they actually cite for the cost is an article that talks about what the cost of sexual abuse or rape is for society, not for Jane, not for Pauline, not for Nia, but for society, the criminal justice cost. So it is completely inapplicable and should provide no guide for this court. And the victims are not entitled to restitution for what it costs the criminal justice system to prosecute Mr. Kelly. That is not, and that's what the article is about. Secondly, they still have to show a proximate cause. Now, here's the unique problem with this case. The conduct is 25 years old, and so the proximate cause issue is not, it's a little more complicated. And some self-reporting that my hypertension or my, feelings about something are caused by Mr. Kelly is not, it should require a little more than self-reporting. I think we should at least be able to see if some victims have actually sought mental health treatment in the past. So, as the court pointed out, there is evidence that Pauline sought mental health treatment in the past, which I guess is an indicator and a cost. We don't have any receipts for that, but let's just say we take her at her word of that. But for instance, Jane, there's not a single statement that she's ever sought mental health treatment. So for that, you say, well, this is going to, we're given a number to project into the future. We didn't even hear that she was going to seek mental health treatment in her statement. She's not here to tell us that. That does not meet the burden. And I asked the court, if the court is going to consider Dr. Cooper's expert reports, this is a woman that spoke to these victims on the phone and then diagnosed them with possible things that they could suffer in the future. I'm not even sure how she did that. This is not that type of evidence that is reliable. It's not subject to any adversarial process. She's not subject to cross-examine. And how would she determine, for instance, one victim, varicose veins are caused by Mr. Kelly, Lord? Her varicose veins are caused by Mr. Kelly. I mean, it's really outside the realm. And there's this assumption that, at least with Jane, that she's disabled for life. I mean, there is an Eighth Amendment issue that comes up with excessive restitution awards. Hold on for 1 minute, y'all. I gotta blow my nose. I don't blew my nose. Hell, don't seem like any help. Okay. All right. So it says, and they have an obligation to provide that the proof. They have had years to do it, and what they provided was an expert report that they can use perhaps in their civil lawsuit, which, with how statutes of limitations are going, they probably can bring. So that's what they have provided. But this isn't evidence of restitution. My papers also demonstrate that there's a whole question of whether expert reports paid for by a victim are even admissible on standing ground. You know, it is the government that is asking for the restitution on behalf of the victims that they are entitled to if the burden is met, but not, a plaintiff, or I'm sorry, a victim herself has no personal standing. And these reports, unfortunately, just don't provide a sufficient nexus between this. What they are projecting into the future, which has no past to corroborate it. And there's no nexus, meaning there's no connection. Dr. Cooper doesn't explain how she reaches the conclusion that these damages into the future are related to Mr. Kelly. And there's a whole 25 years in between that could account for at least some of this damage. We don't know. I mean, Jane wants to blame Mr. Kelly for the death of her father. Hmm? What? Oh, yeah. I'm sorry, y'all. Texas. What does she mean? She, for her father? Mm-hmm. Where's she gonna kill the daddy? Her death, her father died, as I understand it, from a heart attack or something of that nature. I mean, I suppose there's a theory out, but we should be entitled to question that. It's a little far removed. It is not what restitution contemplates. And if we're going to put any emphasis on these reports, we should have the opportunity to challenge them in a meaningful way. So I would object to the use of these reports as some type of ground, some type of basis for damages into the future for the rest of these women's lives, when particularly since there's no history that supports that they would actually get mental health treatment. Ooh. Except with Pauline, I guess, since she has indicated she did. Finally, with Nia, as the court knows, she already sued Mr. Kelly and testified at trial that she received a $500,000 settlement. So, I mean, and the sentencing guidelines allow for an offset. Whoa, okay. That's where she worked her magic. Ooh, the sentencing guidelines allow for that offset. So it's too far removed. The proximate cause nexus has not been demonstrated sufficiently. Meaning, probable cause nexus meaning that they have not proven that whatever happened to them, that whatever happened to them is related to R. Kelly, whatever, right? If the court is interested in having that type of hearing, we could do that. But I don't believe that it's appropriate, and we'd object to the reliance on those reports. Wow. The judge says, well, it seems to me that the restitution is not intended to be in the sense. Hold on, y'all. God damn. Text messages. All right. Well, it's adversary, obviously, but in the same sense of a civil trial in which issues of causation, remember I tell you about causation all the time. I told you about causation long before I even had a channel, right? Are very, very iffy. So that would require plenty of time if there was effort to do so for each side to hire experts to depose them and then have a full-blown same thing as if you had a civil trial. Because obviously these three ladies have been seriously injured and are entitled to some kind of uh, recompense. Recompense, I'm sorry. But it just doesn't seem to me that restitution is the proper vehicle to do that. And so with the exception of Pauline, I will award restitution of the $42,000. But it seems to me that as far as Jane and Nia did recover. I thought it was 200 to $220,000, which she said in some an affidavit. I think that she actually recovered, and her lawyer took the rest. So she would not be entitled to any. So with the exception of Pauline, I'll order restitution of $42,000 and deny restitution for Jane and Neil. Woo! Damn, a $500,000 settlement. God damn. And the lawyer probably took 33 and a third. Whoa, that's still a payday. Damn. Hey, my star. Hey, Purple Purple. Hey, Angela Jackson. Hey, Dorothy Vaughn. Hey, Marietta Jones. I said hey to Keith already. Wow. Anything further? And the prosecutor says, Your Honor, just for the record, you know this is, the government objects to that calculation. And we just think that, based on everything Your Honor saw at trial today, the literature before Your Honor, the case law, child exploitation cases, victim need, and mental health treatment. So they're objecting on this, right? So it might be an appeal on this, right? Brought by the prosecution, right? Yeah, they can appeal this. Just thinking about it. So at the minimum, Your Honor, you can estimate what her average hourly rate is. We included that information. You can bear that out a number of years. It is very important to the government representing this district and the victims that we need to ask for that, Your Honor. And we feel strongly about this issue. If Your Honor is not comfortable with the reports that we provided, we can, put an additional information in front of Your Honor. And you have the ability to hold this over for a period of time. You can review additional papers and issue a separate order. We're asking that be considered. The judge says, I considered that, but it seems to me that what they should have done or should do is bring a civil suit against Mr. Kelly and then proceed accordingly. I appreciate the fact that he appears to be judgment proof, but as you know, as I guess I pointed out once, who knows, maybe if he gets a mega million, he'll be $1 million, he'll get $1 million settlement actually. But if you consider the issue that the situation that the government, their liens of 10 million, as I understand the IRS, that with mounting penalties and interest, that they double pretty quickly. So if it was 10 million, it's probably 15 or 20 million now. God damn. So we're not talking about any really practical that we can do anything for these people. But it seems to me that what they really should do is go to the tort route and sue him for the damages that he obviously did cause to them, but without specific payments, with the exception of Pauline, who indicated she spent $42,000. I'm going to deny restitution for the others. Anything further? Jabo says, Judge, the last issue that I would like to just place on the record is that historically, when Mr. Kelly has been either found guilty in the Eastern District of Sentence Bureau of Prisons, automatically puts him on suicide watch. And the policy, as I understand it, is that he is supposed to be assessed. Because of the Epstein factor, when you're a high profile, they automatically put you on suicide watch. It seems like, and it actually required me to file a lawsuit against the BOP in the Eastern District of New York because he was not suicidal. They put him on suicide watch, and suicide watch is in and of itself a pretty cruel and unnecessary for his own mental health. In fact, it creates mental health issues. So I want the record to be very clear here. Mr. Kelly was very aware of the sentencing, what he was coming into. He already under a sentence of 30 years. He perfectly understood what the consequences were. He understands his sentence here. He is not suicidal. And if the BOP conducts an appropriate assessment of him, they will find that he is not suicidal. So I want the record to be clear. I understand that the court has its own limitations in how the BOP runs, but I do not want to make it a matter of public record that I have spoken to my client. There are no surprises here, and he was expecting this. And there is absolutely no reason for him to be placed on suicide watch. And if they place him on suicide watch, that to me, that would be seen as an interpretation of punitive action that's unjustified. The judge says, all right, as you point out, that's an Article 2, an Article 1 job to do that sort of thing, not an Article 3. And so, with the record, we'll show that you have made that statement. And it's up to the Bureau of Prisons to make that decision, not for an Article 3 judges. Anything else then? The prosecutor says, yes, Your Honor. The government moves to dismiss the forfeiture allegation in the indictment. The judge says, all right, without objection, the forfeiture is dismissed. The prosecutor says, nothing further from the government, Your Honor. Jabo says, nothing further from the defense. Thank you, Your Honor. And I certify that the following foregoing is a correct transcript from the record of proceedings in this above entitled matter. Wow. So that's what happened. So that is what happened, y'all. Mm, 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 mm. So we still have a question on the table. We still have a question on the table. What is going on with the damn letters? What's going on with the letters? Yeah, she puts Robert name in the obituary. Wow. I remember somebody saying that. What do y'all think is the big thing about the goddamn letters? And that situation won't be heard. It can't be heard on appeal. Absolutely can't be heard. It's not on the record. It's on the record in Illinois, but it don't even matter. Are they going to do ineffective system of counsel saying, hey, you didn't bring that up? Okay, but they're probably already doing ineffective system of counsel in New York. So that's just one more thing. You know, and I'm asking y'all because, I hate fucking around with time. A lot of shit, that's going on that could be done. And I hate the fact that I hear his voice and he sounds like he is becking on his thing, right? Yeah. So what's next is he is going through the appellate process, right? That's what's next. And I think they got an extension to submit their brief for the appeals in New York. And here's the thing, right? So when it comes to an appeal, you tell them when your brief will be ready, when it will be submitted, right? You tell them, okay? You make the dates. It's a little, everything is a little, the timing is different from when it's going through the regular trial process. And then, during the post conviction motion phase of it. But when it comes to appeal, you tell them when you're going to have your brief ready. Hey, Sonya Davis. So it should be interesting, y'all. This should be interesting. And I'm not dashing nobody's hopes and things like that. That's not what I do. Okay. I just deal with the facts. Um, I don't see where the attorney is making a push for this BOP stuff on Twitter and Instagram and all of that. You guys be following that stuff going on. Is she making a push for the BOP email situation on that? Baby, I thought um you said that that she wasn't injured. Oh, they didn't read that. I mean, it didn't say that. Did they even address her? Um, it could have been up during the somewhere up. I just read, just the order of restitution, right? It could have been up somewhere in the when he was when they was going back and forth making their order. Let me see. Okay, let me read this. Let me see if I can read some about the sentence. Let me read the sentence. Damn, the sentence got a lot of pages. Hold on. It's on my supervised release. All the facts and sentences were valid. 24 months on, but I'm going to make the part of going to that he can speak on public records. I think is a part of her argument. Right, but you gotta understand with the appeal, you can only argue stuff that was objected to, right? That means stuff that's on the record throughout the trial process on the lower court, right? They didn't say anything about those BOP emails in New York that was objected to or that was preserved on the record. I don't remember anything about that. You know, if he did, maybe transcript man or somebody read it on the transcripts. I don't know nothing about. I don't remember hearing nothing about that with regards to the court process. And remember, the brother Johnsons and stuff, they were in charge then. Yeah, Jim with the pen. So, you want me to put up the like? So, I mean, seriously, like that's a big. That's a big. Shit, my throat itch. I don't know. I just learned that y'all taught me so much about a lot of this black shit. I just learned how to like kind of scratch your throat in your ear or something and wiggle your ear. But I can't even make them know. You know how to all that shit. I can't do that. I'm not gonna do that. But I be trying to get it. Hell, I had ordered something to stick down my ear scratch it. I don't know how to get it like y'all be getting. Boy, you be seeing some people they be and shaking their ear and shit. I was like, oh shit, I don't know how to do none of that. None of that. Girl, girls and guys, I don't know what to tell you about this shit, I just hate to hear his little voice like that, like he's depending on his emails. I'm like, dude, they might need to tell you that this is one of the things. Because when I heard him say, "Don't focus on nothing else," I'm like, "Oh no! What you mean don't focus on nothing?" Hey, Queen Brielle, she be popping up out of nowhere. But yeah, I'm like, "Oh, don't. What you mean don't focus on nothing else?" So let's see. It says. Okay. I'm probably for second 12 months. I put his gum in my mouth. And check this out right here. He keeps referring to Judge Donnelly and his shit. Hold on, let me see. Okay. Okay, so let me read the part. Now we get into the issue of deterrence and protection of the public, which is a very important issue in sentencing. And that's been impressed by the government, saying that this man, he should not be allowed out where he's going to be doing exactly what he did before. And Judge Posner said courts often acknowledge a lower rate of recidivism among older defendants. Let me chew this gum real quick. Hold on. What's up, Chi-Town? What's up? That's U.S. versus Jackson. So the specific deterrence here would appear to be relatively minimal. Defendant will be 80 if he's alive when he gets out of the New York sentence, or close to 80. And his method of operation, his MO, has come out during the course of the trial, was grooming young girls. Now, he was grooming the young girls when he was in his 20s, and he was a millionaire, and he was a superstar. When he gets out in his 80s, there would be few young girls that would be susceptible. I'm sorry, susceptible. Choose that. I'm gone. Would be susceptible to his charms as a 80-year-old with no money and no prospects. 80-year-olds are more interested not in grooming young women, but probably in their prostate and their arthritis and the other, and the factors that go into the aging process. So anyway, as far as if I was going to sentence Mr., I would probably have, considering all the factors that I've outlined before, I would have probably have had a variance upward from the top end of the guidelines, which was 168. Again, I think that there is some evidence justification for the obstruction, and some, and because of the increase in the wait a minute, and again, I think there was some evidence justification for the obstruction. Okay, so he did believe in the obstruction, and because of the increase in the current guidelines, so that is all probability. If I was sentencing Mr. Kelly as a result of, I would probably give him a sentence in the neighborhood of 240 months. What's 240 months, y'all? Hold on, let me see what that is. Bro, that's the 20 years. Oh, okay. So I will, if it seems to me that under all the facts and the circumstances, that is a valid sentence, the 240 months. But I'm going to make the only part that's going to be consecutive will be 12 months. So the sentence would be 228 months concurrent to be followed by 12 months consecutive. I have to work that out with the various counts, but that would be the sentence. So check this out right here, right? So now he got to spread it out amongst the various counts that he was convicted on, right? Because remember, 3 of the counts carried 10 years, and the other 3 carried 20 years, right? He got to figure out how you gonna spread that out, okay? Because just say she appeals this, and if some of the counts get acquitted on or dropped, get dropped or whatever, then that takes away that particular amount of time that he applied to that count. So he got to figure that out. He just made a whole mess of every goddamn thing. You understand what I'm saying? Excuse me. So what was the terms of supervised release of Judge Donnie? Does anybody know? Jabo, I do, Your Honor. What were? Hold on, I have to pull it up real quick. Judge, pardon. I can pull it up real quick. Is it much different than what Mr. Alford has suggested? I guess put another way, Ms. Bonjean, have you reviewed the proposed terms of supervised release? Jabo says, I have, Your Honor. Judge says, I think, well, it's relevant. It's not particularly relevant. Are there any that you object to? Jabo, I did not see any, Your Honor. Just said, is the government satisfied with the proposed terms of supervised release? The prosecutor said, I'm sorry, Your Honor. The judge said the terms of supervised release that were suggested by Mr. Apper. The prosecutor says, yes, Your Honor, those are acceptable to the government. The judge says, okay. So I will make them concurrent with the terms that the supervised release imposed by Judge Donnelly. I assume that she did have a term of supervised release in the sentence, did she not? Jabo said, yes, she did. Court says, okay. So he's making the terms of supervised release concurrent with Judge Donnelly. So it would be served after Judge Donnelly's supervised release. I don't even remember that being in there. But okay, let's go. Let's keep reading. It says, now, whether or not that can be done, Mr. Apper, is that something that can be done, or is that just total confusion if there's differences? He don't know either. He the damn judge. He confused. He asking Mr. Apper. Right. Me asking Mr. Apper. Okay. Mr. Apper said, I believe that there can be a difference. The court says, pardon? Shit, he can't hear either. Mr. Apper said, I do believe that there can be a different sets of conditions. He has the New York conditions and the Chicago. He confused as hell, child. He don't remember. He don't know. He's sitting up there. The judge says, I said making them concurrent is probably irrelevant anyway based on the length of the sentence. Jabo says she ordered 5 years supervised release, Your Honor. Oh, wow. So she orders 5 years supervised release. I didn't know that. I don't remember hearing that. And the judge says, all right, well, why don't we just leave it that way? Do I have to impose a term of supervised release? Baby, he don't even know. He just asking. He don't even know. Do I have to look at him? He probably looking back like I'm looking. Do I have to pose a term of supervised release? Shit, he don't know. Mr. Apple said, yes, Your Honor. The judge said, okay. Why don't I just pose a 5-year concurrent one under the same? Is there any objection to that if I make them under the same terms, meaning under the same terms as Judge Ann Donnelly? He might as well should have called her. He keep referring to her. Kind of shit. Get your shit together, sir. And I'm just making a joke out of this, but they do that all the time, right? They do it all the time. Mr. Apper said, Your Honor, I will note the maximum term of supervised release is 3 years. He don't even know. He was going to give him 5 years, and the maximum term is 3. And the judge said 3 years. Okay. 3 years concurrent to the 5 years then, and I'll waive a fine because of inability to pay. So the sentence is 240 months, not 228 months, concurrent to the New York sentence, 12 months consecutive to the New York sentence. No fine, terms of supervised release. What did I say that I wasn't going to impose? Huh? Jabo say 3, right? 3 concurrent. Judge says 3 years concurrent under the same terms as imposed by Judge Donnelly. And also, how many counts is the $100 special assessment for how many counts? The fuck? Your old ass. The prosecutor says 6, Your Honor. Judge says 6, so $600 special assessment. Mr. Kelly, you're entitled to appeal the sentence imposed. Do you understand that, sir? All right, Kelly said, yes, sir. Yes, sir. Yes, sir. Ooh, I believe I can fly. I believe I can touch the sky. I think about it every night and day. It's playing around. And so, what's up, Samantha? Okay, and then the judge says, I'm led to believe by Miss Jabo that you intend to appeal. And J-Bo, will you take care of the filing notice of appeal for him? Is that correct? J-Bo said, yes, Your Honor. And Judge said, Mr. Kelly, if you can't afford an attorney while on appeal, one will be appointed to represent you. And one will be appointed to represent you on that first time. Now, if that person, gets released, acquitted, whatever, then you're on your own. Okay? So, and so, do you understand that, sir? And R. Kelly says, yes, I do, Your Honor. I'd like to take this time to sing one of my songs. When I be calling people and I say, do you understand? Do you remember when a woman's fed up? Do you know that song? And everybody say, yeah, we know that song, Kels. Who don't know that song, Kels? When a woman's fed up, da 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 da. Ain't nothing you can do about it. La 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 da 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 da. It says, Mr. Apple said, Your Honor, two things. One, I just checked and I did misspeak. There is no mandatory supervised release. The judge says, all right. Mr. Apple says, that must be imposed. There's no minimum term. What's up, New Black? I don't know. Okay. And then the judge says, okay. Mr. Apple said, my other question would be, if you do, judge says, just to make it easy, why don't we just not impose a term of supervised release? They done spent a whole goddamn 30 minutes on supervised release. Lord have mercy. You would think everybody would know, right? They don't know. And they have the case. Meaning they have the files. They have all the information in front of them. Shit, we would have known if we was in there. Okay. If we would have rolled up in there, if our time by Angela would have rolled up in there, we would have had it all together. Shit. Okay, and it says, Mr. Alfred says, the only concern with that, Your Honor, would be if something happens with the New York case and there's an appeal, then there would be no supervised release to follow in this case. The judge says, well, Mr. Alfred says, if for some reason that the conviction was overturned or case vacated, I do believe that the term would be appropriate in this case to run concurrent. Oh, look at Mr. Alper. I think Mr. Alper is a probation guy. He wants the goddamn case to run concurrent. Because he said if something happened in New York, baby, it is on and pop in, right? And the judge says, all right, I'll make 3 years term of supervised release under the same terms as imposed by Judge Donnelly. J-Bo, so concurrent, Your Honor. Just say pardon. He can't hear. J-Bo, so concurrent. Just say concurrent, yes. So in the event that the sentence is vacated. Now we proceed to the issue of restitution. Okay. So y'all, god damn. Let's see, you only got 3 years to serve and then get some revenue. No, that's not how it goes. Okay, so well, yeah, what is the 3 years and all of that? Hold on. So I just went through the sentencing part. Where's all that extra? I just went through the sentencing part. I just went through the sentencing part. It's 3 years supervised release. Mm-hmm. Sorry, somebody texting me. Right. So I don't know. I don't know what all of that is. What y'all talking about? He got to do the 20, and then he got 5 supervised release from Ann Donnelly, and then after that he got the 3. Now they didn't. I didn't see a part where they said, he can be paroled after a certain amount of time, right? Didn't say nothing about that because I didn't see anything about that. So it is the 20. And I knew something was crazy. I was like, well, why would hold on. So I was like, well, why would that? And see, that's why, say what y'all want to say. That's why pitching in to get this paperwork is important. That way we find out exactly what the fuck is going on. All right. So here's the sentence, right? He got 30. So I didn't even know, or maybe I didn't listen to it or whatever. Because here's the thing, right? I was there for the ending of the reading for I went for the I did the verdict over there with Atmos. I didn't do the sentencing. All right. So I didn't know about the 5-year supervisor release over there. So he got to do 30, and then whatever the calculation. I think you get 56 days off per year, something like that, whatever, with the feds. And then you got 5 years supervised release, right? That means he still got to do his 30 years. And then you got 5 years supervised release, meaning that's he got to be supervised, right? And then he got to do 20 19 along with the New York sentence, which is concurrent, and then got to do 1 year consecutive. And then he has 3 years supervised release over there. It's not he gonna do 3 years and then he can start applying for parole and all that. He got to do his time and um then get out. Mm-hmm. Child. That old ass man didn't know what the hell going on. Now it's like, now, dude, how many times you done gave somebody a sentence in Chicago, and you don't know what time of day it is? If you don't get your ass out of here, hey, Ready Red says Angie, that was bloggers putting it out that he would be released after serving 5 years. Now I understand the supervisor releases after serving. Right, Ready Red. Exactly. Well put. Thank you, honey. See all the smart people. I can't keep saying that. That don't be on that bullshit rolls up and through him. Scrolls up. Yeah, you're exactly right, baby. And supervised release is not parole or probation either. He didn't announce. He didn't give a judgment with parole. Mm-hmm. James, leave people the hell alone. You always in here fighting with people and shit. Yeah, I'm glad I read that because I would have went on what everybody was saying. Yeah, it was like even the reporters and stuff had done said it, had to put it out wrong. Lord have mercy, Jesus help me, Lord help me. I'm tired of y'all. Y'all gonna put out the right information. I'm sitting up here. Child keep texting me about bullshit. Trying to get my damn stuff. Y'all, do y'all look at? Listen, I could easily turn this into a goddamn a reaction channel to them damn reality shows and just shows and period. Like, oh my gosh, did y'all see that damn uh Mr. Murdoch? He got goddamn sentenced. And then they talking about Trey Songz. Y'all saw what I put because I'm on vacation, but they say Trey Songz documentary would be worse than R. Kelly's. They say Trey Songz be beating hoes up. They show one girl in the hospital where Trey Songz beat her ass. And listen, let me tell you something. Oh, wait a minute, let me take a sip of this. Lord, that purple box punch. But listen. Now you know I'm getting nervous. And I hate to be having when my gut don't never fail me. My heart may, sometimes make me have poor judgment. My mind sometimes no. My mind make me have poor judgment. My heart sometimes may mislead me, but I really don't use a deal with my heart. People talking about that know me talking about I'm heartless, but I don't think so. But let me tell you something. They don't talk now. They don't connected Chris Brown with that Diddy shit. Remember, it was some came out with some girl and Chris Brown was at Diddy's party. Chris Brown rolls with Trey. Chris Brown is real cool with T.I. Now listen, Chris, Lord have mercy. I would turn this shit into the Chris Brown sector quick. And baby, I'm telling you right now, I will pick a side. Hey, y'all ain't got to worry about that. I will pick a side, baby. Where were the parents, baby? Them group assholes. Get them titties back. Okay, where I can buy me some shirts. I already got my Crocs for marching. Free Chris, okay? Listen. Them group assholes. They wanted it. Shit. Where were the parents? It's just scaring me. I mean, they like when the girl said that Keke Palmer was like she was in the closet or something and shit like that, and she was intimidated to be in a video. I'm like, what the fuck? That Hollywood shit is some crazy stuff. I done heard all kinds of mess. And I know that when something that looks like it was going to kick off, I know how to exit. I politely say, this don't seem right. I've had friends where, and let me tell you something, they do a lot of rigmaroling through their bodyguards and just, little staff they have around and stuff. I don't have friends go all the way to Texas, following behind them goddamn stars and shit. All kind of stuff. And they willing to board planes. I don't do planes. I wasn't gonna go anyway. Mm-mm. You know what I'm saying? Because but they were willing to do all kinds of shit. I got a whole bunch of pictures I could, I popped up one picture with my friend with Bobby Brown a few years back. I put that on my wall, but honey, mm-mm, they got a lot going on. And he said, why are you harassing Reddy Red, James? Why is she responding to you? You just fucking around. Hey, Samantha. I think I said, hey, Samantha. Jane, Reddy, you're using the system. You know how it works. And Harry, I make straight A's, but I listen when you deal with people who won't listen. Wait a minute, what y'all talking about? Who won't listen? Now they have Beyonce Beehive movie out of control. They got a Beyonce song coming out, and then check this out right here. And then they got this dude saying all kinds of shit about Beyonce and Jay now, and I think somebody beat his ass. Oh Lord. Oh my goodness. I think somebody beat his ass, y'all. Oh no, no, I'm pretty sure y'all do not. I just be messing with him. I just be messing with James. Cause he a troublemaker. He like to start shit with me for no reason. His country. But oh my goodness. I don't know, y'all. I just don't like. Well, ain't got nothing to do with me, but he just seemed, R. Kelly just seemed like he is dead set on this BOP shit. Like this is the golden ticket. And I'm like, R. Kelly, this ain't gonna work out. Cause I don't know who gonna hear it. Who? They ain't gonna be heard on appeal. Really, Red, you more country than I am. I want me a good roast, y'all. Oh my god. A good damn roast. Okay, Marsha, how you gonna call my butter troublemaker? Oh, cause you one too. You should know. Both of y'all twin troublemakers. Just making trouble everywhere you go. Just troublemakers. You know what to say. Trouble damn makers. Trouble man. Mm-mm-mm. Ooh, child. I'm trying to put my head on my goddamn knee. Crack my damn neck. Y'all, I don't know. I was watching some stuff about Waka Flocka. Let me tell you something. Those white people, they make some good ass documentaries on black folks. You hear me? I was doing some work today, and all I got the damn dirt about a whole bunch of damn black people from who? White people. They do their goddamn homework. They almost like rap historians, right? I mean, I heard the story about Waka Flocka. You know, he got all those brothers, and he's lost, I think, two. One was two or three. Right, you all in the same boat. Me too. You know, I'm country as hell too, girl. But he lost all those brothers and stuff. I was watching this thing about this lady. She married Joseph Laura, and they died in a plane crash. I think 2021. But it's some weird shit was going on with them. I watched it about the housewives and stuff. What I can do is I can put that stuff on and just key right through it, work right through it. You know what I'm saying? Mm. And then, oh yeah, I'm finna get off him because you know Zeus, y'all gonna pay them people that $6.99 a month and get that entertainment, so y'all can stay in the know. Listen, and that's how I knew about Christian Rock. I didn't know anything about no damn Christian Rock. You know, I knew about her when she got on the Bad Girls Club and stuff. And then, from there, I be, keeping up, not keeping up really, but with her fucking foolishness. But listen, y'all. So do y'all remember the Bad Boys Club, right? So you know how we are about sayings around here. I be saying things or whatever. People be saying that. We be repeating each other's sayings and shit. Be coming up with them on the fly or whatever, right? So I was JoJo was asleep, right? And I was saying, I was like, I was saying where the money resides, where the money resides, where the money resides. And so JoJo go wake up talking about where the money resides. And I was like, JoJo, don't say that because it's that gay guy that say this. And I don't know how some guys are funny. Some macho guys, they be funny with shit. Some macho guys probably don't want to say gay guys saying. You understand what I'm saying? So I had to stop him. Don't say that. Don't say where the money resides. I know it sounds good, but don't say that because that's what that gay guy said. You know what I'm saying? So I don't know. You know what I'm saying? I don't know what they want to say right here. So hey, shit, where the money resides, where the money resides. I like that saying. Shit, I love that where the money resides. But that's that. What's his name? He's in Orlando, not Orlando, New Orleans, where the money resides. He be sticking out his butt and stuff. And when I tell you, they fight like straight women was on that damn show. But Jonathan, the one that do that hair, he fought more like a man. Well, he was fighting more like man. He was beating motherfuckers up. When he got that chair and just was hitting that dude all across his ass, I was like, oh my gosh, somebody stop him. And one thing on Zeus, they let him fight a little bit before they break it up. But Natalie, honey, she's making money. And then they had that little fight with her and Tommy. I shared that, but somebody took it down. Yes. So now I got to go. They fought on the undercard with Mayweather. So now I got to go and see how did Mayweather, how did Mayweather and that dude, how that fight went. But I don't know why Mayweather out here risking his record and his life to pick up these petty and little, this little bullshit. But they were over in London. So, but anyway, let me get off here because, honey, I got a little time to watch this bullshit. And then I got some few things to go. And then I am going to bed. But anyway, y'all, that's all I wanted to know. Those questions. Do you think that the prosecutor will appeal his sentence because they, feel like they, wasn't in feeling it? And then two, where at what point are they going to hear anything about them goddamn BOP emails? Or is this just a goddamn fucking, I don't know. I don't know. I just don't like wasting time, but whatever. All right, y'all. Thank y'all for stopping on through. I don't know when the next time I'll be on here, but I will holler. Love y'all, and y'all have a nice night. Have a good weekend and a good week. Bye, y'all.